Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution and its honorable court.
Good afternoon and welcome to another virtual convention of the Court of Appeals for the First District of Texas. We have one case on the docket today for oral argument. Case number 01-20-00641-CV, State of Texas versus Cal-Maine Foods, Inc., DBA Wharton and Wharton County Foods, LLC. Can we have appearance of counsel on behalf of appellant State of Texas?
Benjamin D. Wilson on behalf of the state, Your Honor.
And on behalf of the FLEs?
Your Honor, Craig Stanfield on behalf of the Cal-Maine defendants.
And Mr. Wilson, are you going to reserve time for rebuttal?
Yes, Your Honor, I'd like to keep 5 minutes for rebuttal.
5 minutes for rebuttal. Okay, well, as soon as we move Mr. Stanfield off the screen, you may begin, Mr. Wilson.
Thank you, Your Honor. May it please the court. Cal-Maine raised prices on eggs by 300% during a declared disaster, knowing that buying was panic-driven. The district court erred in every respect when it dismissed the state's complaint seeking to hold Cal-Maine accountable for that price gouging. Section 1746.46b12 is not unconstitutionally vague. It does not violate the Dormant Commerce Clause. There's no regulatory taking, and Cal-Maine's grab bag of other arguments fail. At a minimum, judgment under Rule 91A was inappropriate because there are numerous questions back throughout this case. If Cal-Maine's right, then neither the state nor Texas may have recourse in a disaster to prevent, for example, a gas station from charging $12 a gallon for gas during a hurricane, or for a grocery store to charge $10 for bread or water during a winter storm. They're declared as disasters. Go ahead, Erin, please.
Thank you, Mr. Wilson. So is there a difference between those scenarios that you just mentioned where a particular gas station is overcharging for a gallon of gas versus a distributor who is following market pricing? In your example, are you meaning that we're talking about one particular gas station charging more than all the other gas stations in the area?
It could certainly apply to either. Your Honor, I think what that runs to is sort of some of the arguments at the back of their brief, talking about, the state can't bring these claims because they're not a consumer. We have several arguments on that point. I think the most straightforward one is there's a separate statutorily available action for the state to bring. And the legislature created a separate cause of action for consumers. So we just don't think the consumer bar applies to the state when the state brings an action. The state has to, for example, show public interest, and there would have been no point for the legislature to create sort of separate actions if the state was bound by the consumer standard. We would also note.
Let's talk about the price of eggs. All right. Was there any other distributor besides Cal-Maine charging $3 a dozen?
Your Honor, I think that in the complaint we said that the price of eggs generally rose in Texas. I think what we also made clear was that Cal-Maine what we alleged is that Cal-Maine is the dominant egg seller in the state of Texas.
Dominant to what extent?
I believe we said they have 90% of the growing facilities in Texas. I don't think that matches on perhaps entirely to how many that they're distributed or that they're distributing in Texas. But we also did allege that I don't think we put a number to it in terms of sort of distributor sales, but we certainly allege they're the dominant seller in the state.
All right. So if they're the dominant seller, what was the price of eggs in Oklahoma?
Your Honor, I'm not sure that the specific price of eggs specifically to Oklahoma is in the record. What is in the record is that egg prices rose nationwide.
Egg prices rose nationwide and Cal-Maine's prices rose while those egg prices were rising nationwide.
I think that's right, Your Honor.
So what do we look to see what the price of eggs was?
Well, in the record, we have what the price in our complaint, we have what the price of eggs was immediately before the disaster was declared. I think it was something somewhat less than $1. We also have various sales
You look to the Irma Berry market report, correct?
that is certainly one indication. I mean, I don't know if there may be folks who sell eggs without reference to that price, but it certainly seems to be the case that is a price that is used in the industry.
Would it be fair to characterize that as the industry standard price?
Your Honor, I think whether that's an industry standard price is itself a question of fact. I think they certainly say it's an industry standard price. But I certainly wouldn't quibble with the court that is a price that may be relevant for purposes of proceedings.
So what is our inquiry when we're trying to determine whether the $3 a dozen is exorbitant or excessive? Do we look at historical data, or going back to 2010 or 1900 or wherever, or do we look horizontally and look at what the prices were in, say, the Dallas market, or in Oklahoma or California or New York?
Well, Your Honor, I think what you would look to, the statute also includes taking advantage of a disaster. So I think what you would look to is the price before the disaster. So there are a couple of sort of inquiries there. One is whether the price was excessive or exorbitant.
Where was this disaster?
There is certainly a disaster declared in Texas. I imagine there were also federally declared disasters. I imagine many other states declared disasters.
It's probably a worldwide disaster.
2 years in, I wouldn't fight with you on that point, Your Honor.
Right. So it's not a situation where, say, a hurricane has flooded Houston and people are bringing in eggs that they're buying for $1 a dozen in Dallas and selling them for $3 a dozen in Houston, correct?
I think that's right, Your Honor, except I would point out that we do have allegations in the complaint about what the input costs were. That's driven both from their public SEC filings and other things that Cal-Maine has said without discovery. And those filings say that they did not have the sort of input costs that you would expect it to rise.
Can I ask for a second? Do you think that their cost is significant in determining whether or not they engaged in price gouging in this situation?
I think it's certainly relevant, Your Honor. I mean, I think the sort of test, as we set out in our brief, discusses what the price was before the disaster, discusses whether that price would be a price that you could charge without losing business absent disaster. I think really how these sort of input costs and things like that might become relevant is as a question of fact past the 91A stage. So, for example, if what you could show with evidence was, well, gosh, because we had to take all of these precautions because of the coronavirus, or because our supply chains were deeply disrupted, or because the price of feed went way up or something like that, I don't think you'd be taking advantage of the disaster if you could just say, well, look, my prices rose and I passed those prices on to my customers. I think if your prices go up 300% because there's panic buying in the market, or people think they really need eggs because of the disaster, it is relevant.
But none of that information is available at this early stage of the proceeding, is it?
That's precisely correct, Your Honor, and that's a large part of why we think that dismissal pursuant to Rule 91A was not appropriate.
So conceptually, let's say, if we're going to factor in the input costs, let's go back to 1973, right, where OPEC has an embargo in the United States. Price of oil hits the price of gasoline hits $1 a gallon at the pump, and let's say Mobil has more efficient production methods than Gulf does, and so Mobil's production, at $1, the unconscionable price of $1 a gallon, Mobil's making more of a profit than Gulf is. Is Mobil, under your scenario and your analysis, price gouging by taking advantage of a national crisis?
Well, to be clear, Your Honor, I think that things like input costs might become relevant as a factual defense. I don't think that they're sort of relevant to the prima facie showing that the state has to make on Rule 91A. I think what the state has to show on Rule 91A is that there's a declared disaster and they're taking advantage of it by charging excessive or exorbitant prices, and that the way that then cashes out.
Doesn't the state allege that Cal-Maine was charging the market price for the eggs?
Yes, Your Honor, but I mean, as we point out in our brief, it can't just be that if everyone is that because everyone is charging the same price, that means everyone can price gouge. I mean, the intuition here is, I think, really straightforward, that the legislature determined, we usually sort of allocate scarce goods and resources in the United States by market price. There are certainly other ways to do it. You can form a queue. That's, we colloquially call that first come, first served. It's also the case that, sometimes businesses limit the number of something people can buy.
I'm having trouble conceptually with the idea that charging the market price, the industry recognized market price, is price gouging.
Oh, well, Your Honor, what I mean to say is this, in the context of a declared disaster, where, for example, demand may skyrocket or demand may be particularly inelastic because people really need something, the legislature has made a policy determination that we're going to allocate these things other ways other than the market pricing mechanism.
Has it made that determination? I mean, it says exorbitant or excessive. I mean, and if it's not exorbitant compared to the market, to the national market, how is it exorbitant?
Well, Your Honor, we think that it's exorbitant, or the correct test is exorbitant or excessive in relation to the price charged before the disaster, and sort of
what was the peak price for a dozen eggs prior to the disaster?
I think it's certainly in the record that prices fluctuate. I believe the price right before the disaster was something like 94 cents.
Well, that's not what I asked. I asked what was the peak price historically?
In history? They certainly say that they had approached $3 at other times in the past. And that was because of things like, and I think we talked about this in our complaint too, things like flus, things like that decrease flocks and cause prices to raise. But it's a very different situation here, where none of that's occurred. I mean,
well, it's because there's no supply side, but the market reacts to both supply and demand. And if there's a market price that has gone up because demand has increased as opposed to supply decreasing, it's still the market price.
I interject something here about the percentages that other states have used to indicate excessive or exorbitant prices. My memory is that there were some that have specific red lines. Kentucky had about a 10% increase from the price prior to the disaster, and it went up to about 25%, I think, in Maine and a few others. So in the 10 to 25% range was sort of deemed to be excessive or exorbitant as a matter of kind of presumption. And here we're talking about what, a 300% increase?
That's
from
right.
Prior to the disaster declaration to just after the disaster declaration. Is there any other state that has a 300% threshold?
Your Honor, the numbers I'm aware of are the numbers that are the statutes that we cited in the brief. I think those range somewhere from like 10% to 25%. And the point we're making with that, I think, is exactly what Your Honor is picking up on, is that whatever the price increase was, or whatever price increase would be available or would be lawful, 300% is far outside the realm of those price increases.
So if the entire industry is charging these market prices, then why is this a selective enforcement against one particular producer as opposed to sort of an industry-wide prosecution?
Sure, Your Honor. A couple of points on that. First, this Cal-Maine is the dominant producer and seller in Texas. And so in a world where the state has limited resources that it can use to investigate these things, to bring cases, it's completely normal and rational for the state to only bring some cases, and sometimes only to bring cases against the biggest players.
What about the beef industry? Did beef go up in price?
Your Honor, my understanding is that, I will tell you, I'm not sure that it's in the record, but I eat a fair amount of beef. So I think beef prices have sort of famously gone up, and it's also widely reported what the challenges with supply chains and things like that in that industry have been. As I pointed out earlier,
The beef producers taking advantage of the disaster by raising their prices?
well, I think if the state brought such a claim, they might have factual. The state hasn't brought that claim, but the state did bring such a claim. They might have factual defenses related to, we had to have lots of folks were out. We had to have spend lots of money on COVID protocol. Our supply chains are a mess, things like that.
Any other questions from the panel? Thank you very much for your time, Mr. Wilson. Now we'll hear from Mr. Stanfield. And because Mr. Wilson went over, we'll give Mr. Stanfield an extra 3 minutes if he wants it.
Your Honor, I'm entirely at your disposal. May it please the court. Cal-Maine follows the prevailing third-party market index to set the price for its generic shell eggs. As the state admits, that pricing was true both before and after the governor's declared disaster declaration. As a result, Cal-Maine continued to charge the ordinary and customary price for its eggs. And it is also true that Cal-Maine did not change its pricing methodology in order to take advantage of the declared disaster.
Are you saying that that's a perfect defense? Let's assume that the price had gone not to $3, but to $100. Would that been okay for you to charge $100?
Your Honor, if that was the published market price as it was nationally, then under AB Smalls and Cohen, we would be entitled to charge that price without being subject to this.
And you don't think that'd be exorbitant or excessive?
Your Honor, if that were the normal customary price that flows out of the pricing formulas from the Urner-Barry Index, then yes, that would be the ordinary customary price that would not have changed in order to take advantage of the disaster. The state needs to show two things. First, that we charge something different than our ordinary pricing formula. We are not the price setters. We take the prices published in the index. The second thing the state has to show is that we changed pricing methodology in order to take advantage of the disaster.
Do we have the contract in front of us?
No, Your Honor. The record talks about it for our investor presentations and that we have long-term supply agreements with our retailers. But beyond,
We don't have the contract in front of us to look at, do we?
No, Your Honor, but you have paragraphs 5 and 29 of the state's petition, where the state admits on the face of its petition that grocers, retailers, that those who actually sell to individual consumers price according to Urner-Barry, and they purchase from us according to Urner-Barry.
Do you think it would be helpful for us to see the contract and making this determination?
No, Your Honor, in light of the state's admission on the face of its petition, that guides and what the state relies on in that petition guides what this court uses to rule on this Rule 91A appeal. The court does not need the contracts to affirm the decision below.
But what's your response to their position that this is not necessarily proper for a 91A motion and that discovery should be had for the contracts and any other relevant information?
Your Honor, my response to that is that we need only read what the state chose to put in its petition, which happens to be true, which is that the entire retail industry, whether it's Sam's, Costco, Publix, H-E-B, that they buy according to the Urner-Barry Index, and that we as Cal-Maine sell to those retailers according to the Urner-Barry Index. That's on the face of the petition. There's no fact finding that needs to be done. We agree with that. They've alleged it. They have to live with that. Furthermore, Your Honor, you can look at anything that the state has quoted from or cited to in its petition as well. But again, I think if you look at paragraphs 5 and 29 of the state's petition, it fully resolves the questions we're talking about now, which is, did Cal-Maine charge the Urner-Barry prices? And the state admits that we did, both before and after the disaster declaration at issue in this case.
Is there a force majeure provision in the contract?
Your Honor, I'm not aware as to whether there is, and we don't believe that would impact the resolution of this appeal. Because again, Cal-Maine, and this is in the state's petition, Cal-Maine is not a price setter. Cal-Maine's prices go up and down and have historically based upon what the published index says the price is. And this is in the record as well. So in 2018, when there was no disaster declaration, prices were at or above $3. The next year in 2019, they fell to 64 cents. They were also at $3 in 2015 because of the avian flu.
So you think that people should do exactly what they do in ordinary times when we're in the middle of a declared disaster or emergency, is that right?
Your Honor, this isn't a policy determination that we're putting forward. What we're saying is that regardless of how we believe the statute is void for vagueness on its face, but if the court were to apply a meaning to the statute, then the state has to meet two different tests. One, they have to show that we charged a price that was not ordinary and customary. And second, they have to show that that price was charged in order to take advantage of the disaster.
I thought it was one sentence, not two sentences. I'm just looking at the statute. Doesn't appear to be two sentences to me.
Your Honor, whether it's one sentence or it's two sentences, it's got multiple clauses.
I'll read it if you'd like.
No, I have it as well, Your Honor. And what I'm saying is that when we look at 0.46B27, it has subject to 4625 that you have to take, it's taking advantage of the disaster declared by the governor under chapter 418, et cetera, by, and then it has subsections A and B. So it does have multiple parts, and all of that language has to be accorded meaning, otherwise it's rendered mere surplusage. And so the state's reading of taking advantage, you could, under the state's reading, completely take that phrase out, and the statute would mean exactly the same thing as the state interprets it. And that's something that the court can't do when it's interpreting statutory text. And so on the face of this statute, though, and I want to go to your questions, Justice Kelly, the national market prices were essentially the same. They were over $3. And those prices are charged to Sam's, Costco, Walmart, HEB, Publix, Aldi, et cetera, pegged to those market indices. And so when we are confronted with this statute and with the statute in all of the case, in all of the states around the country that have statutes that have, as you point out, Justice Goodman, varying levels of enforcement, whether it's 10 to 25%. 19 states have exceptions and defenses when you have a volatile market and you follow the market. Multiple states have exemptions altogether for agricultural goods. And so when we're confronted with a statute that does not provide us with a clear benchmark against which we can judge our prices, then we run headlong into a vagueness problem. Because as the statute is written, the prices don't even have to change. On the face of the statute, it only requires that at the time of the declared disaster, that a fact finder determine those prices are exorbitant or excessive. So you could have exactly the same price. And the state lauds this alleged flexibility on page 8 of its opening brief, where it says that plaintiffs have great flexibility in determining how to bring the case, but that is exactly the wrong way the statute should be interpreted. Because as a penal statute, and the one that implicates our right to interstate commerce, it has to be narrowly construed. And we have to be able to judge what is in and out of bounds under the statute. And the two cases that are most on point, we think, for us are A.B. Smalls and Cohen. Two cases that dealt with the sugar market in the early 1920s. And those cases were reaffirmed by the United States Supreme Court in Johnson versus United States in 2015. And what those cases stated, to go straight to your point, Justice Goodman, in those cases, they stated, we understand that surely someone could bring an example to us, like $1,000 for a bag of sugar, and say that this is unjust, unreasonable, or excessive, which was the language of that statute. But simply because we can find examples that would clearly meet the statute's definition does not save it from a constitutional standpoint. And there it was struck down, both under the criminal and the civil versions of those statutes. And we think those cases are most important. Similarly, under Johnson versus United States, in 2015, a much more recent Supreme Court struck down the Armed Career Criminals Act, even though over Justice Alito's dissent, they said we could find examples where this statute clearly applies. But there's so much unknown that we can't. Justice Kelly, I see you're leaning in.
Actually, he's getting a sip of water.
Oh, okay. I wanted to be respectful if you wanted to ask a question. So all of that, go ahead, Justice Guerra. I'm sorry.
I was going to ask, so what's the difference between this and, for example, the Sherman Act, that it also is very vague in its delineations?
I really,
Clayton Act.
Sorry, say what?
Or the Clayton Act.
I really appreciate those questions. So in fact, the Supreme Court dealt with those in the Cohen and Small decision, because in 1913, in the Nash decision, the Supreme Court upheld the antitrust statutes. And part of the reason why they distinguished upholding the antitrust statutes, but striking down the price control statutes during World War I, was because those antitrust statutes incorporated into themselves a tremendous amount of common law that then people had something by which to gauge their conduct. There was an expansive body of law that they could go to say, this would be in and this would be out. But as the court said, go ahead, Justice Kelly.
What requires, do the contracts require the CalMaine to refer to the Urner Barry pricing market?
Yes, Your Honor. Much like the oil and gas market has for long-term supply agreements, although they rely on NYMEX or Platts, the pricing with our large retailers is either a premium or a discount over a regional index. And I do want to highlight on that for just a second. For Texas, Texas is in the south central region of Urner Barry. It is not a Texas-only market. This is a market set by multiple states, and we think that's important to our dormant commerce clause argument. But to answer your question specifically, there is a spot market where people can buy and sell based upon that pricing, but there are also long-term supply contracts that say, for example, we will buy at South Central less 2 cents or 5 cents, or maybe they'll pay a premium to it. Again, that's not necessary to resolve this appeal, but that is how the market works.
But we don't have those contracts in front of us, do we?
No, Your Honor, and you don't need them.
Well, I understand your argument is we can just refer to paragraphs 5 and 29 of the state's complaint. But setting that aside, we don't have the contracts in front of us right now.
That's right, Your Honor. What you have is the state's admission that CalMaine, both before and after the disaster declaration, which incidentally still runs today, has always charged the market prices to its customers who are not end-use consumers.
Could CalMaine have charged, say, $5 a dozen?
Your Honor, no. The mark for 2 reasons. One, that's not the Urner Barry index. It never reached that price. And as the state also admits in its petition, our customers, even under long-term agreements, are fully able to enter the spot market. So when Urner Barry is at $3 and we offer a $5 price, then no, we won't be able to sell those eggs. That's simply not the market price. And we do not have captive customers. So for example, Justice Guerra, I think you touched on this. This is very different than a situation where someone may be on a highway and there may be one gas station next to them and not another one that they can get to. And that gas station has a captive market. That's not the situation here. And in fact, what the state seems to allege, although it's not supported by their pleading, is that maybe they wish they had brought some sort of antitrust claim. Maybe they wish they brought a different claim. But we do not control the market. The state does not allege that we control the market. And in fact, what the state alleges and admits is that we are one part of a very volatile, fragmented egg market that simply follows the market prices when they go up and when they go down. But in effect, what the state would have the DTPA do here is work extraterritorially, because these are prices that are entered into by CalMaine with national retailers to govern national contracts. And again, those prices change automatically based upon the index. But in effect, and the state concedes this, given the patchwork of state laws out there that govern price gouging, if they all were to be invoked at the same time as they were here, then our only other option is to find the most restrictive statute and follow that pricing, presumably for 2 years and however long the pandemic goes on, that our prices can never change. There is no exception or defense in the DTPA for increased cost of goods. There's no exception or defense in the DTPA for market changes in prices. There's no exemption for agricultural goods. And as the record here demonstrates, prices over the last 10 to 15 years have fluctuated from 55 cents to over $3. And they've hit the $3 mark 3 times. Avian flu 2015, the retail wars in 2018, and then the pandemic for only 3 weeks before they fell again down to around $1 for a dozen eggs.
So in the states that have the more restrict, for example, the 10% rule, do you sell at a different price in those states?
Your Honor, our position wherever we are is that we follow our contract. Because again, we are not changing our pricing in order to take advantage of the disaster, 1, and 2, because we don't sell to individual consumers. We always sell to retailers. So someone coming to us individually saying, I want a dozen eggs, we don't sell to those individuals. And the way the vast majority of price gouging statutes work is you have to sell to an individual consumer buying for home or personal use. It does not reach conduct between sophisticated businesses which is what the state is trying to do here.
All right, I didn't really hear an answer to Justice Guerra's question, but Kentucky has a 10% limit, if I remember correctly. Are you saying that you didn't increase prices by 300% in Kentucky?
So, Your Honor, just as a minor point, first of all, under Kentucky, we followed the market because Kentucky has an exemption and a defense when you're using a pre-existing price formula or contract. So our conduct was not prohibited by the Kentucky statute. And second, although maybe a bit pedantic, going from $1 to $3 is actually not a 300% increase as the state alleges. It's a 200% increase. I do acknowledge that's still larger than 10%, but taking the Kentucky statute on its face, we have an absolute defense under that statute because we're following a pre-existing price formula and contract.
But you admit that we don't have that same defense here in the DTPA.
And that's what causes the Dormant Commerce Clause problem for the state of Texas. On the face of the statute, and I understand the state would like this court to read language into the statute to limit it, but on the face of the statute, the state can govern pricing conduct wherever it occurs as long as it directly or indirectly affects a Texan. So for example, if a price is entered into between a Mississippi egg company like Cal-Maine and an Arkansas company like Walmart, but those eggs end up in Texas at a heightened price, then that contractual arrangement is going to be subject to up to $250,000 per violation by the state if it affects someone over the age of 65 in Texas. And that's precisely the Dormant Commerce Clause problem here, just as it was in Frosch and in Healy, because we have a patchwork of different states' laws that when put together, make it such that you have to follow the most restrictive price out there if you want to be in compliance.
I'm sorry, is there a claim for damages in this case or just a claim for?
Civil penalties. So they have alleged civil penalties and disgorgement. This is a classic penal context where the claim for relief that they have is unrelated to the actual damage or harm to an individual. And because it is a claim for penal damages, that is why this court, under binding case law, has to narrowly construe the statute in a way that benefits those who are governed by the statute. And we think that's an important point because this statute doesn't just govern commercial actors, it governs any person who may sell a product of any sort that falls under the statute's purview, which is quite broad, as long as that conduct directly or indirectly affects a Texan. And so you could have, to use the state's language, a mom and pop who thinks, well, right now, this is what the price is. This is what the price is nationally for this product. The governor declares a disaster, and that mom and pop organization on the corner has to decide, is my price now exorbitant or excessive? Now, the way that we believe the statute should be read, if the court can find a constitutional reading, is that they should not be punished, in part because if they don't change their pricing in order to take advantage of the disaster, if they're following their ordinary and customary pricing, then that should not be violative of the DTPA here. And Your Honors, I'm happy to answer any other questions that you have, but I also want to be respectful of your time.
Any other questions from the bench? Thank you very much, Mr. Stanfield. And now we will return to Mr. Wilson.
Thank you, Your Honor. I think I'd like to, since my friend on the other side spent a lot of time discussing the Dormant Commerce Clause and extraterritoriality, I think I'd like to take that on first for a minute. The first problem with their extraterritoriality argument is that the statute is limited to conduct in Texas. That's 17.4625. I'd also like to point out, they rely on the Online Merchants Guild case throughout their briefing that was on this point. That was a district court case out of Kentucky. The Sixth Circuit reversed the district court's determination in that case. It's at 995 F3rd 540. And it did so under logic that's completely consistent with the state's arguments here. In that case,
So how can we say that Cal-Maine took advantage of the disaster if what they did was following the formula set in the long-term contracts?
well, I mean, first, Your Honor, as we've sort of discussed it several times here, we don't know what those contracts say.
Okay, well, let's just assume that the contracts say that they're going to be the Berry index, either a premium or a slight discount on that. But for these purposes, say the Berry index price. And they entered into a contract in 2015 saying, we'll supply you X many eggs for 10 years at the Berry price. Now, the Berry price goes up in the time of disaster. So how has Cal-Maine actively taken advantage of the disaster? When all they're doing is following the contract that has been in place since, say, 2015.
Sure, Your Honor. I mean, a couple of points. I don't mean to fight your hypo, but I would like to point out that there may be force majeure clauses in those contracts. We don't know that any of those contracts ran from 2015 to today. There are all sorts of factual problems. I'll stop. I swear.
That's the point of a hypothetical, right?
No,
hypothetical.
Of course, Your Honor. The answer is that there are a couple of different pieces of that answer. One is that the DTPA doesn't have sort of a knowledge requirement or an intent requirement or anything like that. You can violate the DTPA whether or not you need to. The second is, Your Honor,
let's just think about that phrase, taking advantage, right? I mean, that implies some sort of willful activity to take advantage,
Well, Your Honor, I think what it implies is charging a price that the market would not support but for the disaster. And that's sort of exactly what we have here, where egg prices went from something like 94 cents.
Right, but they're contractually bound. So they're bound to charge the Berry price, whether that price is 60 cents, where they're losing money, or $3, where they're making more money. That's provided for in the contract.
Well, Your Honor,
it's a private allocation of risk between the wholesaler and the retailer. So we've had this private transaction, this allocation of risk according to the market price. How has Cal-Maine on March 10th, 2020, then taken a step to take advantage of the price? How have they changed their position? What action have they taken that takes advantage of the disaster?
Well, they've charged prices that the market wouldn't bear otherwise, which is exactly what the legislature prescribed in the limited event of disasters.
They're contractually obligated to do that.
And also, isn't it that the prices, as Mr. Stanfield told us, the prices had reached that high on other occasions outside of this time period?
Your Honor, I think we don't dispute that prices in the egg market fluctuate and that prices had reached something around $3 before for various reasons. What we say here is that the price precipitously went up as in a disaster demand for eggs became very inelastic and increased because people were panic buying, and that was not a price that but for the disaster would have been supported. And Your Honor, if they want to raise as a defense past the Rule 91H stage, that this is what naturally would have happened in the market anyway. Prices always go up around Easter, they say. We think prices would have been $3 at this time otherwise. Those are things they're free to do. It's just not something that's appropriate to deal with at the Rule 91A stage.
And what's your response to their argument about the demand and that causing the increase in price, and how if they hadn't increased the price, then you would have had even more panic buying?
Well, Your Honor, I mean, I think that's a policy choice for the legislature to make. I mean, there are various ways that goods get rationed during a pandemic or a disaster or when demand is particularly high. What the legislature has decided is that that when a disaster drives demand, you can't raise prices 200% or 300% or what have you, and that those things are going to be allocated in other ways. I'm happy to answer any further questions the court has. I see my time's up too.
Thank you very much, Mr. Wilson. Thank you, Mr. Stanfield, as well. Cause number 0120-00641-CV is now submitted, and the First Court of Appeals is now adjourned.